Welcome to Mind Over Matter. Today my guest is Marcia Boumil, who's an attorney and director of the Comprehensive Family Evaluation Ctr at the New England Medical Center, where we both work. And today we're going to talk about guardian ad litem. Who are they? What do they do? What don't they do? Et cetera, et cetera. So perhaps we could start with what is a guardian ad litem and who becomes what?
Okay. Well, a guardian ad litem is an individual who is appointed by either a probate court or a district court, typically on behalf of a child, for the purpose of investigating a situation which the probate court or the juvenile court feels needs to have an in-depth evaluation by somebody who's trained to do so.
Like what? Could you illustrate what a situation or two might be?
In the probate situation, it is often a custody matter, a contested custody matter. Mom wants custody, dad wants custody. The court is left to decide who is the better custodial parent. It might be a visitation issue. In the juvenile courts, it might have to do with parental rights, whether or not a parent has adequate capacity to care for a child, whether a child has been abused or neglected, and what the effect of that abuse or neglect should have on the custodial rights of the parents.
Okay. So I'm a judge, and so I'm likely to turn to an attorney, but what do you bring to the table? How do you help the court decide a custodial parent, for example?
Okay. Most guardians ad litem have some kind of clinical background, a background in child development, a background in psychology, perhaps a background in psychiatry if there are issues that need to be evaluated by a psychiatrist. So most of them have got some kind of clinical background in child development or family matters. There are some that are attorneys. And those who are attorneys typically are in this field because they too, even though they're licensed as attorneys, may have a background in psychology or a background in child development. The probate courts prefer to have people who have at least a master's level degree in psychology or child development. But there are some issues that are primarily legal issues. And in those cases, it may be just as appropriate to appoint an attorney as a psychologist.
So a judge will decide sort of what
the question is.
What the question is,
and who is best able to answer it.
Okay.
And then, of course, there are some that have training in both. And since most of these decisions are, in fact, both legal issues and psychological issues, to the extent that a guardian ad litem has training in both, the court might call upon that person to do a broader range of tasks.
Okay. So, for example, around custody, the judge appoints you, let's say, as a guardian ad litem. What does the judge want you to do? And I gather implicit in that is that you then are really an agent for the court?
Yes. We clearly work for the court. Although we are often paid for by the parties, our obligation is to the court and to the court only.
Okay.
The court will decide, based upon the individual case, what it is that needs to be investigated. So, for example, the court will identify custody as an issue because the parties have come in and each said that he or she wants to have custody, or it will be visitation. But there are also other issues. There may be allegations of substance abuse, so the court asks us to do a substance abuse evaluation. There may be allegations of domestic violence. We may need to do a domestic violence evaluation. There may be allegations of physical or sexual abuse, so we are asked to evaluate those issues. So the court, by the time it appoints somebody, has a pretty good idea of what the issues are. It just doesn't know what the resolution of those issues is.
So is it fair to say that some judges may feel the issues, complex though they may be, the court can settle them on the spot? I guess, how does the judge decide which cases will require a look-see by a guardian ad litem and which cases won't?
Almost always, if there are contested issues of custody or visitation, the court will find somebody, whether it's a guardian or the alternative is one of the court's own probation officers, who also do this kind of work. Probation officers are often asked to do so in cases that are somewhat less complex and, more importantly, somewhat less time-consuming. So if it's a situation in which the court thinks that probation can resolve the issue with a relatively limited investigation and consistent with the training of the probation officers, then it may very well assign it to the probation officers. It may also have to do with practical issues such as whether or not the parties can afford a guardian ad litem, because it's a pretty expensive undertaking and not everybody can afford it.
Okay, so a decision could be made on that basis?
It can be made on the basis of how complicated it appears to be, the resources of the parties, and it should also be noted that the state will also pick up the bill in cases in which the issues are complicated and the parties are unable to afford it. Then the state will, in fact, pay for it. But a guardian ad litem is appointed in cases where the issues are sufficiently complex that the court really feels that it needs an in-depth look. And probation officers just don't have the time to devote 20, 30, 40 hours to a case as we might.
Okay. But now, I know, because it's happened to me, that sometimes a court will refer a problem to me, and I'm just a psychiatrist, and basically ask me to assess and write a report to the court. Often the request is coming through probation. So is that another level of information gathering that the courts turn to? They just simply make private referrals?
Well, it sounds to me, I'm not entirely sure what the mechanism is, but it sounds to me as though the court needs a limited assessment. It needs a psychological evaluation, or it needs some psychological testing, or it needs a mental status evaluation. It sounds to me that rather than investigating an entire family situation, that it's a limited issue, which is just as easily given to a clinician who's going to address that limited issue rather than looking at the whole family.
Okay.
Because at the point that you're now looking at that whole family, it's a pretty in-depth evaluation, and it's typically done by a guardian ad litem.
Okay. So depending if it's narrow, they might just simply make a referral out and expect a report back from someone like myself. If it's more comprehensive, well, if it's very simple, they could just decide from the bench.
Right.
But if it's very complicated, then you're saying they're likely to then appoint a guardian ad litem. And that person, I would assume by definition, unlike guardians in general, you're looking for objectivity. You're looking for somebody who's not a relative, obviously, who's not attached in any way to the situation.
Right. Must have no conflict of interest in terms of knowing any of the parties or having any vested interest in the case.
Okay. And I'd like to get into some of the mechanics of actually how you go about doing some of these assessments, and maybe we'll save that for after the break. But maybe you can give me some ballpark ideas on in-depth. I mean, when you talk about in-depth, maybe could you define it both in terms of what you do as well as, say, the number of hours you might anticipate a case is going to take for you to then properly go back to the court with your assessment?
Okay, all right. We start off typically with at least anticipating 20 hours to do an investigation, and that may be the determining factor as to whether or not the court thinks that its own probation department can handle the investigation or whether it needs outside resources. So a minimum of 20 hours to do a comprehensive evaluation, but it can easily go to 30 hours or 40 hours. During that period of time, we're going to meet with, for example, let's assume that we're looking at a contested custody case. Mom and dad both want custody, and there are 1, 2, 3 children involved, perhaps more. We're going to meet clearly with the parents individually, maybe together, but at least individually, maybe twice, maybe 3 times. We're going to meet with the children. We may, again, perhaps individually, perhaps together.
At what age do you not do that? Is there a...
Meet with the children. In my experience, a child who is 4 to 5 years old needs to have an opportunity to speak.
Okay.
And even children that are younger, I always want to at least observe them. So even if we're talking about a 1 or a 2-year-old, I will always want to at least see that child with each parent, because you learn a lot just by looking.
With each parent?
With each parent.
Oh, okay. Do you go to collaterals?
We go to collaterals. We'll talk to school teachers. We'll talk to friends and relatives to a limited extent, usually only if there is some particular reason. So, for example, the babysitter is an important person to talk to. Therapists, to the extent that we have permission to do so, are valuable resources.
And sometimes you don't get permission?
Sometimes we don't get permission. Yes, you as an adult maintain your right of confidentiality unless you either voluntarily waive it or the court, under a particular provision, can determine that in child custody cases it's more important to involuntarily waive your privilege.
So if my warring spouse knows I'm in therapy, that's not admissible unless I give permission for that to be...
Well, the fact of therapy is going to be admissible.
Okay.
But the content of your therapy is only going to be admissible if either A, you say so, or B, the court, after a hearing, determines that the well-being of the children outweighs your right to keep that confidential.
Well, it's getting interesting. We have to take a break.
Okay.
Maybe we'll pick up with some of this, because I think the devil's in the details, and it'll be very interesting to explore how you go about it. So we'll take a break. Thank you. Sorry.
AT&T Broadband of Norwood and Westwood will hold a 6-week workshop in video production to train local volunteers. The workshop will teach volunteers how to use camcorders and studio cameras, and also train them in lighting for the sets, creating graphics, post-production editing, and audio engineering. AT&T Broadband currently uses trained volunteers on many programs such as town meetings, high school sports coverage, the 4th of July parade, and high school graduations. Workshops are held at the AT&T Broadband Studio located on 375 Vanderbilt Avenue in Norwood. The workshops are free of charge. Volunteering your time will help bring local events and programs of interest to your community. To register for the workshop, contact Kerry Darris or Jerry Comic at the AT&T Broadband Studio at 781-769-7668. That number again is 781-769-7668.
Here's the list. Your half.
My half. Tyler.
Janelle.
James. Something noisy.
Oh, and Keisha. Oh, she likes puzzles.
Sounds good.
Dad. I know.
Good. Okay, Aunt Betty.
Something sweet.
Good suggestion, honey.
Mom. A house coat.
Oh, didn't we get that last year? Friend Paulo. A tie.
Didn't we get that last year?
Cousin Larry. Got just the thing.
Okay. Little Sammy. Something cuddly? Granny Mae, perfume.
New perfume.
Eric?
The twins.
Oh, anything that matches.
Cousin Frank.
Gail, she's got everything.
JJ.
Oh, anything. He won't like it. Now, your cousin Katrina.
A husband.
Eric?
Gary.
Carol.
Caroling. Gary.
Carol.
Caroling.
Okay, so let's go back to this. A judge now has asked you, and maybe you want to quickly talk about your program, because you did indicate prior to the show that sometimes the judges prefer to refer to a program rather than to just single experts who might be able to perform the function. Sometimes there's a certain preference for the kind of program that the New England Medical Center runs.
Well, there are certainly some very highly trained and highly skilled guardians who work on their own, and judges are very happy to have them and to be able to assign work to them. But there are other situations in which the judges prefer to have a program that they can refer to, primarily because there may be multiple issues involved. There may be substance abuse and domestic violence, and there may be sexual abuse. And there may be a need, for example, for psychological testing, and it's unlikely that a single person is going to be able to do all of that. So the judge might want to refer to a program, because I can then assign somebody to do the substance abuse piece, somebody who is an expert in substance abuse evaluation, or I can assign a person who specializes in sexual abuse of children, or I can give the psychological testing piece to a separate individual, because there are those who think that that psychological testing is not objective if it's done by the same person who's doing the evaluation. So there are benefits to having large programs where different pieces might be given to different individuals.
And how many such programs are there in Massachusetts, for example? Do you know?
There are 4 hospital-based programs that I know of, and I think that there's another one out in the North Shore, which is not a hospital-based program, but a collaboration of several people.
Okay. And I do want to get back to the mechanics of how you do what you do, but maybe this is a good point. Who pays your center, and who pays for these evaluations? And can you give me some idea, I guess, what it costs?
Okay.
Yeah.
The judge decides who is going to be making payment. In a good number of cases, it is the parties. I would say the majority of cases, it is the parties. It may be the mother, it may be the father, it may be split, and the judge decides based upon the economics of the case, which we know nothing about and have no part in deciding. The judge makes the decision as to who pays us. And it is clearly important to us to make sure that who's ever paying does not make any difference in terms of the outcome of the evaluation, because that's a concern that people often have. In those cases in which the parties cannot afford a guardian ad litem evaluation, and the court nevertheless thinks it's necessary, the Commonwealth will pay.
Okay. And let's say it is a 20-hour evaluation. Roughly what is the cost to have your center do such a study?
A 20-hour evaluation is going to run in the range of about $3,500. But it is not at all unusual for that to increase substantially quickly.
Quickly. And then as you get more and more into the complexities of it, the parties are paying as they go, or how long, let's say, does a 20-hour evaluation take?
Typically, the courts like us to have the evaluation done in about 90 days. There are some circumstances in which they will ask us to expedite it because of the critical nature of the situation. There are other times when it takes considerably longer than that. But a typical 20-hour evaluation ought to be able to be done in about 90 days.
In about 90 days, okay. And there's a certain merit, I would think, in just tincture of time. I mean, you can kind of, you get data by seeing how some of the issues play out over time.
Exactly,
Yeah.
exactly. We're taking a snapshot at a particular point in time, and people, to the extent that they can, try to be on their best behavior during the time that we're taking that snapshot. But it is our experience that if the evaluation does, in fact, drag on for 4, 5, 6 months, which is not unusual, that the snapshot becomes more of a panoramic view, and we do learn more. But it also, at some point, there needs to be some finality, because people's lives are in turmoil during this period of time. If they're both looking for custody and that decision is outstanding, that's a stressful period of time, and people need to have closure at some point. So dragging it on for too long becomes counterproductive, and also contrary to the well-being of the children, whose lives are also in flux during that period of time.
Now, just before we get back to the mechanics of the assessment itself, how old am I as a kid before you weigh heavily my wishes?
Okay, well, first understand, please, that we are not decision makers.
Okay.
We only make recommendations. So the question is, at what point might the court give substantial weight to the interests of the child? The cases have said that sometime around 13 or 14 years old, we begin to give some pretty substantial weight to what a child wants. Not decisive weight. There are certainly reasons why the interests of a 13 or 14 or 15-year-old, if that child even expresses an opinion, because very often they don't, and very often it is clinically advisable to not ask. So if a child expresses an interest in getting involved in that kind of decision, then somewhere around the early teens we begin to give more weight to what the child wants.
Okay. So let's now pick up with the assessment. You meet the spouses, perhaps several times, you said.
Perhaps.
You meet the kids.
Yep.
And you observe the younger ones when they're younger than, say, 5. Then what happens?
We ask people who else has relevant information. Again, it may be school teachers, guidance counselors, pediatricians, physicians of other sorts. It may be neighbors who have observed something, babysitters. To a limited extent, we might ask friends and relatives. So we go through whatever collateral sources are have got relevant information. Now,
do I have any say in limiting the list? Let's say I don't want you talking to my son's 8th grade school teacher. He doesn't like me. The teacher doesn't.
Chances are, if that person is not on your list, or is on your list of people not to talk to, chances are your wife is going to have that person on your list. And even if it isn't, if the information is not privileged and that person is willing to talk to me, then the fact that you don't want to is probably going to flag for me the fact that it's important for me to talk to him or her.
So you're going to really...
Don't tell me who you don't want me to talk to.
Yeah, and with obviously within the limits of the confidentiality laws, you're going to try to collect as much data as you can that'll help you recommend to the court an outcome.
Right. Okay. If you don't want me to talk to that teacher, I would like to know why.
So
sometimes
the 20 hours is enough time often? What makes it... Okay, so 20 hours is the spouses, the kids, a few of the collaterals.
It often is not enough time.
That's what I was going to ask.
It often is not enough time.
When does it begin to escalate, the time requirements?
In cases in which there's any complications in terms of inconsistent information, people who are telling us different things, in any case in which we don't have a pretty clear idea of what's going on with the family, we're going to need to do more digging. We may have to have more interviews with mom or dad. We may want to talk to grandparents.
Now, let's say I've spent half of $3,500 and I say, ouch, I have no more money for this and I want the process to end. And you feel that further work is required?
Well, there may be situations in which people genuinely do run out of money. And once we undertake to do an investigation, we need to do a full and fair and complete investigation. And regardless of whether or not we're ultimately paid for it, we need to produce a product for the court, which is a fair representation of what we would have done if there were more time. Now, that doesn't mean that we're not aware from the beginning, usually, of what the resources of the parties are and how much we can do. And there are discretionary factors in terms of how many times we interview people, how many collateral sources we look to. But once we undertake an investigation, we need to complete it, regardless of payment issues.
Now, in all of this investigation, does suddenly the truth emerge? Do you suddenly get a vision of what a good outcome is? I mean, how complicated and difficult it is for your team sometimes to come up with proper recommendations?
Well, there are those cases in which it is very complicated, and those are the cases that we worry about. Those are the cases that we still wonder a year or 2 or 3 years later whether or not, in fact, we made the right recommendations. And again, it isn't decisions, but it's recommendations for the court. And there are times that we don't sleep well at night, and we worry about whether or not we've made the right recommendations. We do the best we can. The team approach allows us, and we do on a regular basis, meet with each other, have case conferences. We meet at least monthly. Sometimes twice a month.
And you review all your open cases?
No, we review those cases in which any one of us feels needs to have reviewed. We also can discuss individually with each other a case in the event that rather than the availability of the whole group, we want to talk to 1 or 2 others about a particular situation. We can do that. We often do that. We consider that to be the value of having an organization. But in the end, we have to recommend what we believe is best.
Okay. Well, let's take a break, and then maybe we can look at the kinds of recommendations and the court's response and kind of what the ripple effects are.
Okay.
Thank you.
Excuse me. Excuse me, are you Santa Claus? I heard you might be him. If you are him, here's my list.
Help the Marines make Christmas possible for less fortunate children. Donate a new toy to Toys for Tots.
Here's Santa Claus.
California? That's a long flight.
Yeah, but I'm not worried. I've got a direct flight early in the day, so I won't have to change planes, and I'll beat the heat. I'm in a sturdy, well-ventilated kennel with proper USDA markings. Oh, and I put my humans on the same flight. Coach, of course.
That's one smart dog.
Fly smart. Think ahead when traveling with your pet.
As time flows on, there are places we return to again and again. Places that comfort us with their serenity. Places that astound us with their beauty. Places where our memories come to life. precious places, timeless places, places that with your help can endure forever. I'm Paul Newman. Help the Nature Conservancy save the last great places around the world.
What you're not will come either here or at the end too. Okay, I guess I'm very interested to know, you've done your assessments, you've reviewed the case, you've collected a ton of information. How do you put it together, and then what do you do with it? I know you then make recommendations to the court. You don't make decisions. How does it work?
Okay, well, in the appointment itself, the judge will often tell us what the issues are.
Okay.
Here's what I want you to investigate. Here's what I want you to report back on. So that becomes the parameters or the guidelines for what it is that we're supposed to do. So if the court is not interested in recommendations on custody, but really just wants to know whether or not grandparents ought to visit, then the scope of what we do is to determine whether or not grandparents ought to visit. So the court will begin by telling us what it is that we're going to investigate. Once all the data is gathered, we do in fact put it together in a report that will be filed with the court. There's a debate of sorts within the industry as to whether or not we should be making what is known as ultimate issue recommendations. Should we tell the court custody should go to dad or custody should go to mom? Or should we simply give the court all of the data and let the court make that decision? And I think that there's a credible debate within the industry where we should stand.
Well, it's the ultimate forensic debate.
Yes.
You know, yeah.
Yes. And I think that there are good issues on both sides. I think a lot depends on whether or not the person who is the guardian feels as though he or she not only understands the clinical issues, but also understands the application of the law to the clinical issues. Because if the clinician feels as though custody ought to go to a particular person, but has no understanding of what the law is going to say about that on a particular issue. Let me give you an example. There was a recent case that says that if a party has been found to have committed domestic violence, that party should not have custody unless the court makes specific findings about why it is that even in the presence of domestic violence, that it is nevertheless in the best interest of the children to be in that person's custody. Well, if the guardian...
Simplify that a little bit. I mean...
you're a wife or child beater, and I, as the guardian, nevertheless think that you're the better custodial parent.
Okay.
I might go ahead and say, I still think that custody should go with him. The court, according to the law, needs to have specific reasons why it is that in the face of that domestic violence, you are still the better custodial parent. If the guardian doesn't know that the legal standard is that we need to have specific reasons, then there may be a recommendation that custody goes to dad, but without adequate legal backup for that decision. So in that case, if the guardian is not familiar with the law, it might be better to simply present all the data to the judge and let the judge make the decision based upon his or her understanding of the application of the law to this particular fact situation. So it's always a hybrid decision. It's the well-being of the children, but it's also the application of the law to the well-being of the children.
And talking about the well-being of the children, you clarified earlier, you're not you're a lawyer. As a guardian at Litem, you're not a kid's lawyer.
That's correct. We are not the attorney for the child.
Now, when would children have lawyers?
In certain statutorily mandated situations, such as care and protection proceedings, The children would have a lawyer representing just the child, in addition to the parents perhaps being entitled to a lawyer. But the children would always be given a lawyer. In the probate courts, where there are primarily custody visitation disputes, children are typically not appointed lawyers unless the court thinks that a lawyer is necessary to represent the interests of the child. The difference is that an attorney for the child is obligated, like any other attorney, to speak for the child. So if the child wants to live with dad, then regardless of what the attorney thinks, the attorney is obligated to represent that interest. The guardian ad litem is supposed to be an objective or neutral source who makes an opinion on what is best for the child. But the attorney would be obligated to advocate.
Okay,
for
now
his
I'm
or
just
her
curious.
client.
You're a lawyer. When you're a guardian ad litem, are you a lawyer? I guess this is a practical question. Do you have to meet with the child and the child's lawyer, or can you just meet with the child alone if you're the guardian ad litem, knowing the child also has an attorney?
When any party is represented by a lawyer, I think it's good form to notify the lawyer that you're going to be meeting with his or her client and to give that lawyer the opportunity to be present. In the vast majority of cases, they don't. They typically are comfortable having clients meet with the guardian. There's not going to be a lot of difference in the outcome. There are rare situations in which a lawyer is going to instruct a client not to answer a question that the guardian poses. And then, of course, if there is, then that in and of itself requires investigation. So in the great majority of cases, lawyers are not present during the guardian ad litem's interview of mom or dad or the child. But I also think it's good form to give everybody the courtesy of being there if they so choose.
Now, is it better form because you're a GAL who is a lawyer compared to, say, a GAL who is a social worker, or you're saying it applies in both situations?
I think it applies in both situations.
And
it's
is the
not
lawyer
a secretive process,
Right.
and we're going to be reporting what we hear. So
these are not secret reports.
these are not secret reports.
Confidential.
We must tell people right up front that we were appointed by the court, that we will be reporting to the court, and that when people like to tell us things, quote unquote, off the record, we have to interrupt them and say, there is no off the record here. If you tell me, it is fair game.
But the report itself goes directly to the judge, and I, as a parent, don't see it.
Well, the report goes directly to the judge, and at the discretion of the court, it may also go to the party's lawyers.
But not at your discretion.
Not at my discretion,
Right.
That's correct. However, it is usual for parents to be able to read these reports. They should be able to see them, and we have to anticipate that the parents are going to see them. The situations that we worry about are the situations in which the children are reading the reports. And for that reason, the court usually instructs that while parties can look at the report and read it in court, they may not take a copy of it and may not be given a copy by their lawyers. And I have had a situation about a year or so ago. I had a situation in which a child called me up and was reading to me from my own report.
How old a child?
It was a young teen. She was either 13 or 14. Too young to be
So
reporting.
generally the court doesn't want the kids to see these reports.
That's correct.
But usually ends up letting the spouses or the people petitioning for custody, usually eventually with the court's purview, have access.
Yes, they should absolutely have access.
Right.
And it would be the rare situation in which the court would instruct that a party could not have access to his or her own report.
Has that happened?
In limited situations in which there was safety at issue. There have been situations in which the report was impounded and not available to one or both parents. But that is the exception. But it's the rule that children should not be involved in seeing these reports.
Now, what if someone breaks that rule? Is there censure? Is there any You know, anything, is there a consequence?
Well, the only consequence is that it's a reflection on parenting if you allow a child to have inappropriate access to what should be adult information. So there could be consequences in that respect. But is it decisive? Usually not.
Okay, so now this is a report. It's roughly how big a report? I'm just curious, how many pages would you say? Is that a fair question?
It's a fair question. Again, since investigations can take 20 hours, but 30, 40, or 50 hours is possible, a report can be as short as 15 pages, single-spaced, and as long as 40 or 50 pages. Although I think that in the vast majority of cases, being concise is a virtue. Judges need to read these reports. They typically would like to stay awake while they're reading them.
Do they? Not stay awake, read them.
Oh, do they read them? I think so. I think
or do
most
they go to the back for the...
Clearly it's a concern of ours that we fast forward through the report and look to what is usually at the end a summary and a section on recommendations. So I always tell people that are interested and ask that the summary and the recommendations ought to be able to stand on their own, because we do worry about the cases in which the only thing that the judge has time to read is that summary and section on recommendations.
And just before the break, once your report is submitted, is your job done?
It may be. It's important to understand that the GALs are appointed in only a small percentage of cases. Those cases in which people just cannot reach some kind of resolution on their own. So if a minimum of 90% of cases are eventually going to reach agreement, it's only that other 10% that requires a GAL. But once the GAL has made his or her recommendations, once again, the vast majority of cases will settle, and people will make concessions, or they'll make some kind of agreement with the guidance of the guardian. Those cases go away. There are the small number of cases, it may be somewhere in the range of 1 or 2%, that actually go to trial. And in those cases, the guardian is likely going to be called as a witness, and we do have to be prepared in every case to go to court.
So that report will be part of what is...
It will go into evidence, and we will be cross-examined on it.
All right. Well, let's take a break, and then let's look at some of the long-term and short-term issues that are an outgrowth of this.
Okay.
Thank you.
For people who have to deal with the harsh realities of life, there is hope. There is Volunteers of America. Volunteers of America has been rebuilding lives and restoring hope to people in need in communities across the country for more than 100 years. Volunteers of America is one of the nation's largest nonprofit charitable organizations, providing services for children and youth, the elderly, homeless people, families, and many others. We serve the emotional, physical, and spiritual needs of more than 1.5 million people a year. Find out how you can help. Call 1-800-899-0089 today. Volunteers of America. There are no limits to caring.
To be a mother, you must know these things. How to hold your baby, feed and care for your baby, but most important, how to be there for your baby. If you die while giving birth, you can't be there. And if you die, chances are your baby will too. So if you or someone you love is pregnant, see a healthcare worker. And be prepared to take action if you see any of these signs: bleeding, severe headache or fever, if your waters break even a little, if your birth pains last more than a day. Get to a health care worker immediately, because before you can hold and comfort and love, before you can care for your baby, you must first care for yourself. The Safe Motherhood Initiative, because our mothers are our future.
Well, we've arrived at the point where the report is done. It's about 15 to 20 pages long, and it gets submitted back to the court.
Right.
What does the court then do with your recommendations?
Well, assuming that the parties then present themselves back in front of the court will read the report, and it will make its own independent assessment of the quality of the investigation and whether or not it's going to accept the recommendations, because they seem to make sense in light of what was discovered. And it will make its own independent judgment about the issues that are before the court.
Based on, I mean, the court, for example, doesn't have, I mean, the judge obviously has his or her own gestalt, I mean, right. But there's no countervailing evidence that's, the report stands by itself. There's no, the loyal opposition hasn't submitted any report.
Right. Well, the guardian ad litem report is typically given substantial weight. Assuming that the court has selected a guardian that the judge has faith in, typically the report is given substantial weight. But there's always the opportunity by counsel to cross-examine the guardian, to try to point out how the guardian was biased or didn't investigate certain critical facts that might have made a difference in the outcome. So good lawyers will certainly do their best to try to discredit a guardian ad litem who makes recommendations that are contrary to the interest of their clients.
And that's not even talking about cases that go to trial.
Well, that would be under a situation in which there was some kind of hearing or trial on contested issues. Often the report is used as a vehicle for trying to reach some kind of agreement or settlement on the contested issues, because certainly because the report is given substantial weight, it is some evidence of what the court might rule.
So does my lawyer see it at the same time the judge is seeing it, or does the judge see it and then copies are given to respective counsel?
Once it's filed, the lawyers then have the opportunity to go and read it. And usually that's done before they get to court. So usually by the time the judge reads that report, both lawyers have already had an opportunity to see it, to read it, to digest it,
and
to comment on it, to
it.
talk to anybody they want. Yep.
Okay. All right, and you're saying that at that point you're not necessarily done, because if they want to, they can try to find bias by cross-examining you in court. You're not off the case.
That's correct. That's correct. Once we finish our report, the investigation part of the process is done. We can at any point be called as witnesses at a trial, and it is not unusual for people to continue to call us with various things that are happening and looking for resolution.
Just to call you on the phone.
Call us on the phone and say, the following has happened, what should I do? Particularly people who are not represented by lawyers, and there's a growing number of litigants who are what we call pro se, representing themselves. We're basically the only connection that they have with the court, and so they will often continue to call us and ask us for advice or for recommendations or for guidance.
So in terms of what you're not, how do you respond to calls like that? I mean, at that point, who are you in their life, and what kind of a role might you have, and what's the proper limits that you need to set on that?
Okay, well, one thing that we are not and shouldn't be in terms of establishing appropriate boundaries is that if we are therapists, it is not unusual for parties to say, okay, well, you've recommended that we need to have some kind of therapy. Will you be our therapist? It is not a good idea for a guardian ad litem to cross that boundary, because we never know when down the road we're going to be asked again by a court to be reappointed to the same case, to the same family, to look at an issue that has arisen since the report. In terms of what we say to these people, well, we need to make it clear to them that we have no longer have any capacity to do anything in terms of making recommendations or getting their concerns before the court. So although we may be good sounding boards, and we try to be courteous in terms of understanding that people are looking for sounding boards, the reality is that we have no legal capacity at that point. We're not appointed to do anything, and there isn't any mechanism or vehicle for us to get their concerns back before the court.
Okay. And your team members are kind of counseled, coached to try to sort of put an end to the relationship.
Yes.
Not to promote it.
Yes.
Okay. And what if I kind of plead with you? You're not a therapist,
right.
I take it, so...
You can't plead with me.
I can't plead with you, but let's say you're like one of my colleagues, a social worker, and I kind of feel a real simpathico to you, and so I, first of all, I'm not told that I should stop calling.
Well, you're told that there isn't anything that we can do for you at this point, that we've made our recommendations to the court, that we don't have any further capacity to, we cannot on our own decide that we're going to be reappointed to do an update, for example. So, so although you may call me with your concerns, there isn't much that I can do at this point because my recommendations are in, my report is in, and I'm not going to, I have no authority to do anything further other than to perhaps listen to you and be sympathetic.
So you listen to me, and let's say I say, you know, you really missed the point about my ex. You've overlooked something that I think is important. Where do you send me? What do I do with that concern of mine?
Well, I guess it depends on where we are. If we are after the report is filed, but before there's been any action on it, then what you might be wanting to do is to ask me to rethink my recommendations. But if we're already have been to court, the decisions have been made, the custody, the visitation, whatever has now been decided, then there is nothing more that I can do in that case.
Okay. Now, do judges ever ignore your reports?
Yes. Yes. I'd like
Why
to think that I personally haven't had that experience yet, but there is a case that came down within the last 5 years in which the report of the guardian ad litem was specifically set aside, and it was done so on the basis that the investigation wasn't competent. And there isn't anything wrong. Judges are supposed to make an independent assessment of whether or not this report was done in a fashion that's consistent with the standards of the practice, and if it isn't, absolutely a court would be required, if it thought the report was not competent, to simply set it aside. Very often it'll appoint a new guardian and start all over again.
Okay. Okay. So obviously the court depends on this information that's provided, and obviously you're providing a lot of valuable information to help inform whatever decision the court makes.
Well, it's also important to document where the information has come from. That's another reason that the report might be discounted or not used. If there's no documentation as to why it is that you've reached the conclusion that you have, and the court can't go back and look and figure out whether or not you've used reliable sources, that might be a reason. The court is more interested in our gathering facts and using clinical judgment to evaluate those facts. It is less interested in having us make ultimate decisions which really require the application of the law to to be applied to these situations.
And do you find most of the time that you're able to come to a reasonable set of recommendations, or are there some cases that you years later anguish about still?
There are the cases in which there just is no good answer. The typical case is a case in which you either have two very good parents, which on their own, either of which could do a very good job raising the children, but that together just simply can't do anything other than inject conflict into the child's life. Those are tough cases because you don't want to take custody away from, or a custodial relationship, whether or not it's custody or half custody or visitation. You don't want to take that away from a good nurturing parent, but the two of them together just simply are a bad combination. Those are tough cases. The other tough cases are the ones in which neither parent is really a good, really the parenting capacity of neither party is very good, and there is sometimes a fine line between being unfit, in which one set of legal standards come into play, but really just being poor parents, poor parenting ability. In those cases, we recommend that the parents go and do something in terms of increasing their own parental capacity. But
where do the kids go in the meantime?
Well, unless the parent is unfit, those parents are going to stay with one or both parents. So those are tough situations as well.
And on the sort of very positive side, have you seen cases work out where you think it's, I don't know, justice has prevailed?
On the positive side, there's different kinds of cases. There's the kind of cases in which, with a little bit of help and guidance from the guardian, that people have been able to reach some kind of, I don't want to say agreement, but perhaps accommodation that works for everybody. And if it works for both parents, then the likelihood is that it's going to work for the children. So there are those cases that we can feel good about. There are also the cases in which, even though the parents don't agree, we're pretty confident that we did what was best for the children. So we sleep well after those cases.
Good. Well, listen, I think on that note, let me thank you on behalf of the Norfolk Alliance for the Mentally Ill. They sponsored this program. I found it very helpful.
Okay. Thank
A
you for
lot of us,
having me.
you're welcome. A lot of us, I do have a lot of questions and curiosity about this whole phenomena, so I think it's been very helpful. So thank you.
Thank you.
Good. Now we can